Check 1 2, check 1 2 3, check. Testing 1 2 3 4 5.
Oh, okay, we're going to pass this around. Okay. Hello, everyone. Welcome. Thank you for coming. I'm Susan Sharon from Maine Public Radio, and we are very fortunate to have a very distinguished and experienced panel, some of whom you might know, but some of whom are not from Maine. Let me introduce them. To my right is Professor Dimitri Baum. He writes and teaches in the fields of constitutional law, employment law, and the judiciary. He's recognized as an expert on judicial selection, ethics, and constitutional interpretation, and he's been involved in extensive pro bono work. His resume is much longer than that, but I'll save that and go on to the person next to him, who's Keith Tyrion, who is, yes, sounds like the character on Game of Thrones. That's how he told me to pronounce it. He's the director of outreach at the Alliance for Justice, where he works on educating and mobilizing the public, coalitions, and organizations about the courts and access to justice issues. He previously worked as the acting director of Equality Maryland. And to his right is Lindsay Morris. She's the associate director of Washington operations at the National Council of Jewish Women in Washington, D.C., where she oversees advocacy, leadership, and organizing efforts. Specifically, she works on engagement on issues affecting women, children, and families, such as reproductive rights, voting rights, and judicial nominations. She previously worked as a tenants organizer at Casa de Maryland, an immigrant rights advocacy organization. And then finally, last but not least, is Zach Hayden. He's the legal director at the ACLU of Maine. He's worked on civil liberties cases involving immigrants, prisoners, religious minorities, whistleblowers, students, and journalists, among others. He's also an adjunct professor here at the law school. So please join me in welcoming this great panel. All right, so let's talk about why courts matter. And Dimitri, I want to start off with you. This past year, while much of the nation's attention was focused on the nomination and confirmation of Neil Gorsuch to the U.S. Supreme Court, filling just one of 9 seats on the bench there, dozens of other job openings in the federal court system were getting less notice. There are currently 144 vacancies, including 135 in the U.S. District Court and the U.S. Court of Appeals. There's even an opening here in Maine, which we can talk about. The number is more than twice as many as when President Obama took office. What is going on? Why are there so many?
Yeah, so I part of it is timing, and part of it is kind of criticism of the previous administration. So when President Obama came in, one of the critiques of the presidency was that he didn't push judicial nominations fast enough. And obviously in the first 2 years of the presidency, he was really focusing on healthcare and the Affordable Care Act. That took a lot of time. And so that was a time when you had a Democratic Congress when you probably could have put more judges through more quickly. That wasn't the focus as much of the administration. And as you went later and later into President Obama's tenure, it got harder and harder to appoint. And so I think he was a little bit slower to appoint. And obviously the Congress, the Senate was very slow to confirm, oftentimes not even holding hearings for a lot of the nominations. And so you had a slow buildup where there's more and more vacancies that were created. And you got to the point where, I think 10, 12% of the federal court seats have become open.
Another problem also is the aging number of judges, right?
Yeah, and the federal courts have gotten older over time as well. It's funny because we see at the Supreme Court level this trend to appointing the younger judges to have them there for a long time. We haven't seen as much of that at the lower courts, but even when that happens, what you end up seeing is with that nomination, you have the average age going from kind of mid-50s to the low 60s, and we have examples of judges who are in the 80s, 90s, who continue to serve in senior status, in part because they feel like they have to because of the number of openings in the courts.
And logistical break. We're going to now feed the mics back out so you can hear yourselves.
Oh, okay. All right. Do you want us to continue?
Yep.
Okay. Oh, yes, now I can hear myself. All right, so let's talk about what the large number of vacancy rates mean for people's cases. That's really the important thing. What's happening to the people because of the vacancy, and what, Dimitri, can you explain, or can somebody else, around the country why there are 60 courts that are considered in judicial emergency.
Yeah, so as far as judicial emergencies, I don't know what exactly the definition is. I think it's based on the number of cases per open seat. So basically, if you have an open seat at a circuit court or a court of appeals, I think it's something like 700 or 600 cases per panel. When the courts reach that number, that's considered a judicial emergency. For the district courts, it's slightly lower, maybe 600 cases per judge when there's a vacant seat. The numbers themselves really are critical because of what it means for cases, right? And so when you have, in the criminal context, you often have criminal cases that drag on for a long time. And we've seen this trend where there's almost no cases that actually get through trial, right? If you kind of think historically, in the civil cases, for example, the jury played an important role. The jury was an important check on the government, and the jury was an important decider of people's rights. We don't see that anymore, in large part because these cases take so long to get to trial, and there's such a long process before we can even get there. Most judges don't have the time, right? So the judge might say, well, look, sure, we can go. You can have a jury trial, and in 4 years, we'll get there, right? But for many plaintiffs, they can't afford to wait that long, right? So in the civil context, that often forces people who are kind of in most need of money to try to settle the case early without taking advantage of their rights. Same thing on the criminal side, where you have a criminal defendant who is kind of forced into a plea bargain because they're sitting there awaiting trial, awaiting a chance to be heard. But with all the openings in the courts, it often will take over a year or two.
So Keith, access to justice, do you want to weigh in on that about what you're seeing on the ground?
Yeah, I would add in that one important point is it does deny people access to justice. That for all of these cases, they represent specific people. They represent plaintiffs, they represent defendants. And when you can't file for instance, class action or a malpractice suit, then people are denied either recourse or remedy, and that's really the impact on it. And it is being able to access the justice system that everyone has a constitutional right to be able to access.
How concerned is your organization about the delays and about those vacancies and what it means?
We are concerned in the big picture about ensuring that people are able to access justice and have a day in court. When it comes to judicial nominations, that includes the quality of judges that are nominated and making sure that they are judges and nominees who will uphold that access to justice issue.
All right, so Dimitri's mentioned, and as you all probably know, that federal judges are hearing both criminal and civil cases in their jurisdictions, and they hear fundamental points about disagreements over the Constitution and congressional legislation. They sometimes help resolve certain state disputes, so it means that these judges have a say in the rights of virtually all Americans around issues like abortion, gay marriage, immigration. Right now, there are several big cases pending. You've probably heard about them in the news, such as this week's challenge by 15 states to the Trump administration's rollback of DACA, which is the Deferred Action for Childhood Arrivals program. But there are others, and there are others that your organizations are watching and even working on, right, in the case of the ACLU of Maine, right? Zach Hayden, can you talk about those?
Sure, absolutely. It's right, and I think Keith's point is exactly right, that we can think about these as cases. Sometimes here in the law school context, we think about the issues at stake, but it really at the bottom, this is about real people and real people's lives. The U.S. Supreme Court, when people pay attention to courts at all, that tends to be the court that attracts most of their attention. It's the one that's most heavily covered in the news, and it is incredibly important. It does, make rulings that affect all of us, and so I don't want to discount that. Their term begins the first Monday in October, which is coming right up. The very first day of the term, they're going to hear a case called Epic Systems, very memorable case, an epic case. Epic Systems is about whether employees can band together to bring class action lawsuits against their employer to challenge, issues related to their working environment, even when most employers have kind of mandatory arbitration clauses that say, employees, if you have any objections, you individually have to go and arbitrate those disputes with your employer. You cannot band together and go to federal court. So this issue of access to justice is going to be right there on the first case, on the first day of the upcoming Supreme Court term. And then the very next day, they're going to hear a case called Gill, which is getting a lot of attention, which is about partisan gerrymandering. It's about the way that districts are drawn for the legislature. And that's something that affects all of us. We all live in a legislative district. Somebody had to draw that legislative district, and we'd like to think that those sort of nonpartisan considerations went into that drawing of that district, and the Supreme Court on their second day of this term is going to decide that. And then a week later, it's kind of front-loaded term. A week later, the Supreme Court's going to hear arguments in a case that my organization's involved in called IRAP versus Trump, and this is the challenge to the constitutionality of the Muslim travel ban that was filed the day after the Muslim travel ban went into effect, and has worked its way very quickly up to the U.S. Supreme Court. On October 10th, the U.S. Supreme Court's going to hear arguments in that case. And that case is, obviously it's been in the news a lot, people are talking about it a lot, but it's about so much more than just the Muslim travel ban and travel of people from these various countries. It's really the first important test about President Trump's authority and how much courts are going to act to safeguard our rights against that authority. So that's just the first week of one court, and then there are many other things that the court's going to be dealing with, just the Supreme Court. And the Supreme Court only deals with about, fewer than 100 cases a year. In the recent years, it's been way fewer than 100 cases a year. Compared to the U.S. Circuit Courts, the 13 courts of appeals around the country, which deal with thousands of cases every year, and the district courts which deal with tens of thousands of cases every year. Here in Maine, we've had cases about the free speech rights of people that want to stand on the street asking for assistance or expressing their views on matters of concern. Courts around the country in Texas and Virginia and Chicago have weighed in about restrictions on voting and requirements that people get ID before voting. So these are all issues that a lot of us care about that courts are called upon to decide.
Lindsay, is your organization also watching specific cases, active in them, and can you explain what those are and why you are?
Yeah, absolutely. Thanks so much, Susan. And what's been said around the panel so far, National Council of Jewish Women, why is a faith-based women's organization involved in this? Because we care about all people, and because everyone's lives are impacted by the decisions made by the judges with full lifetime appointments is something to always keep in mind, and that matters, and we can play a role in that process. So we're a minority religion, and we understand the importance of the separation of religion and state and the role that courts play in that. We're a women's group. We understand the importance of the courts in issues that matter to women, whether it be employment discrimination, whether it be reproductive rights, and we can go on in the list. And all of these issues, voting rights, LGBT rights, impact women and their families. And so we are keeping our eye on all those cases that Zach mentioned, and these core beliefs just compel us to do this work. And understanding that the courts impact the work we're doing in the executive and legislative branches as well, and are oftentimes the final check on the government. And so it's best to keep our eye on it and get involved in the process to make sure the judges uphold constitutional values, like reproductive rights, like voting rights. So I'll pause there.
Any specific ones you want to mention beyond what Zach brought up?
Well, I'll mention one that we talked about earlier that you forgot to, and I'll turn the mic back over because he can explain it better, but it's about a cake.
Yeah, the argument for another case that's gotten a lot of attention, a lot of people are paying attention to it. The argument hasn't been scheduled, but the case is Masterpiece Cake Shop versus the Colorado Commission on Civil Rights, Colorado Civil Rights Commission. And it is, cake is important, but the case is about a lot more than cake. This is a case about two men who went in to try to buy a cake for their wedding, to have at their wedding, and the owner of this bake shop said, I'm not going to bake a cake for you because you're gay. Colorado, like Maine, has for a very long time had a law that prohibits discrimination on the basis of sexual orientation. As part of the sort of comprehensive civil rights laws that we've had in this country for a long time, that people, when they go out into the marketplace, participate in public life, they're not discriminated against on these basis of these factors that they can't control, and that we've decided as a society are invidious. So this case is about that, and whether that Colorado protection against discrimination will be upheld against this Masterpiece Cake Shop's objection. But it's about so much more than that. It's about this whole comprehensive network of protections that we have at our state level to protect us against discrimination in all sorts of forms. And this is especially important at a time when the federal government has been not able to pass and enforce comprehensive civil rights protections for a very long time. It's not something that the federal government, that we can rely on the federal government to do, and we rely on our state governments to do it. We rely on our state laws to provide that protection, and it would be a devastating blow for the Supreme Court to undermine that. And that's one of those cases I think all of us are paying close attention to.
Keith, did you want to weigh in about any more that you're watching?
There are a few on immigration. There are actually a couple on immigration. We are also closely watching Cake Shop. And I would add in, I think Cake Shop is one of those examples of where, yes, the Supreme Court recognized the right to marry. What does that mean if you can't get that wedding cake? Are you actually able to live out that right? And it's an example of where a constitutional right is recognized, but this court case impacts the daily life of whether couples can actually exercise that right.
All right, so when it comes to selecting and nominating federal judges, most of whom serve lifetime appointments, what are the qualifications for the job? And what is a president supposed to be looking for? How does that work? Dimitri or Keith, who wants to take that question?
Well, I can start. There's kind of the idealistic vision of this, right? That you want somebody who's smart, you want somebody who works hard, you want somebody who has maybe some experience on the bench, somebody who's even-tempered. Now, ultimately, we've seen ideology play a more and more important role in the nominations, even for the lower courts, for district court seats and circuit court seats. And people who've studied the courts, there's so much evidence now that ideology is going to be one of the kind of key determiners in how judges decide cases, right? So we know how much it matters, but also all kinds of things about our personal backgrounds, our religion, our race, whether you have a daughter, right? So there's studies showing if you have a daughter, you decide sex discrimination cases differently, right? So all kinds of factors in your personal background can make a big difference. And so it's really important to kind of figure out what kind of a person we want on that bench, right? And I think ultimately we don't want ideology to be the only driving force in the decision. We do want somebody kind of focusing on judicial demeanor and temperament to be as important features.
Yes, because we can only look back to what happened with Robert Bork, which ended up being about, he was rejected by the Senate, mostly because of his temperament, right? And his...
Well, of course, there was an ideological debate about whether or not his ideology was in line with the American people. It's a very hard question, right? Because there are so many different things we might be looking for in a judge, and I think different presidents have looked for different kinds of characteristics. Obviously, in recent years, as I mentioned, presidents have been trying to appoint younger candidates who stay on the court longer. And so we've had nominees, we had judges who've been on the court for 30, 40 years, right? Justice Stevens, who recently retired, he was in the court for 40 years, right? And so the characteristics of the person we pick make a difference in a very long term.
So there's what the president is supposed to be looking for, and then there's what you all are looking for. Keith, what is your organization looking for? What do you want?
Yeah, so I would add in, when it comes to the Supreme Court, there are 2 qualifications under the Constitution that a nominee has to meet. Has to be nominated by a president and has to be confirmed by the Senate. And that's it. Those are the only 2 requirements under the Constitution. And so there's a lot of room there for what to look for. There's a lot of wiggle room. What we look for is we believe that the federal judiciary should protect people's rights, should protect equality for all, should protect the constitutional rights of everyday people and not only the wealthy and powerful. That everyone should be able to go into that court and know that their rights are first and foremost.
And Lindsay?
And I would echo what Keith said, and then I would touch on diversity, and I mean that in various areas. So the strongest judiciary is when we have diversity in gender, when we have diversity in race and culture, and as well as professional diversity. A diverse federal bench improves the quality of justice, and their life experiences affect how they might interpret the facts put in front of them. It'll help them understand the real life implications that their decisions have and to all people. Many studies have been shown that when you have one female judge on a 3-circuit court panel, it affects the entire panel's decision on gender discrimination cases. So that's just one example, and we could imagine many more. So we're also keeping our eye on that. I feel compelled to note, just because I saw an article today, that President Trump, just touching on diversity and from a women's organization, his first 26 nominees, 20 were men and 6 were women. And when we look at society, it's not that. And so, we've had past presidents who also have, if you look at who's on the court, right, there's still a lot more men. So we have a lot of work to do just on gender diversity. But I invite you all, we'll talk more about how you can help get involved in that diversity.
Sure. Right. Think about just the Supreme Court right now, where we have, diversity in the sense we have, both kinds of judges, those who went to Harvard Law School and those who went to Yale Law School, representing the full spectrum of that. But to your point, the point that Justice Ginsburg made years ago, she was asked at an event, what's the ideal number of female justices on the Supreme Court? And she said 9. She thought, and then then people laughed, and then she said, well, we've had 9 men. Why wouldn't we have 9 women? And maybe we'll see that, although probably not in the immediate near future. But it is striking, and so just to add one more point about, you think about like professional diversity, of how what a lack of professional diversity there is on the current U.S. Supreme Court. There is nobody on the Supreme Court that's ever worked as a criminal defense lawyer. There's nobody that's ever served an elected office. Those were 2 things that for generations there was at least one person on the court who, when they went back into conference, could say, here's how in a state legislature it works, or here's what it means to be a governor of a state. But Thurgood Marshall was actually, I think, the last criminal defense lawyer who served, and that was quite a while ago. So it would be nice to have some diversity in those regards.
When it comes to the selection and confirmation of judges, we often hear really 2 different competing messages, right? We hear, one, that judges are supposed to be apolitical and independent and able to call the balls and strikes and serve as a check on the other branches of government. That's one. But then at the same time, as you all have mentioned, the president is usually looking to pick someone from the same political party, and analyzing the judge's record on issues consistent with that party's agenda. Let's be real. So how can anyone evaluate the independence of a judge who is selected from a political process? Can someone explain that, Dimitri?
Well, I can start. So the balls and strikes idea that Justice Roberts brought up during his confirmation hearing, I think almost nobody believes that anymore, right? I think it's very clear that judicial ideology, their upbringing, their political beliefs play an important role in their decisions, right? We can see that in how the court splits in their decisions, and how conservative ideology leads to a certain kind of result, and a liberal ideology leads to a certain kind of result. So I think that's kind of a pretense that I think judges take in the confirmation hearings, but everybody realizes it's more than just calling balls and strikes, right? And if you think about the kinds of cases the court decides, and the kinds of vague language in the Constitution the court has to interpret, it's not like calling balls and strikes, right? There's a lot of personal opinions and personal background that feeds into how judges think about what equal protection means or what the word speech means in the First Amendment. So when you kind of put that aside, then you can see that ideology will certainly play a role. And in fact, it's nothing new. I mean, ideology has always played a role in nominations going back to the founding, right? So I think it's kind of the pretense that it's a new idea that judges are ideological. But I don't think it's inconsistent with the idea of independence, right? And I think when we think about independence of judges, we think about a structural point, right? That a judge is free to decide a case in the way that they see fit. They're not answering to anybody. They're not bound to do anything. And so I think that's an important trait in a judge, right? When we're looking for a judge, you want somebody who's on the court. They may decide a case differently than I would decide it, but at least kind of tries their best to decide the case according to the law, and not just to try to make it the kind of the base of their party happy, or make the nominating or appointing president happy.
Anybody else want to weigh in?
Yeah, and I think we're going to get to the judicial nominations process, so I'm not going to delve in that. But the first piece of the process actually depends on your state. But some senators have a bipartisan committee to kind of cull potential people to nominate. And so when we talk about ideological beliefs, having that bipartisan committee reviewing the applications, making the decisions on which names to send to the senator, who then, right now I'm going to the process, sends it to the president, really helps in that. And I'm also thinking about the West Wing episode, which, good, people know what I'm talking about, right? Like the best scenario is when we have 2 vacancies on the Supreme Court, that we can appoint someone from both sides of the ideologue kind of spectrum, but that's just kind of.
Well, since you brought it up, the process, and if you don't mind, let's start with the vacancy in Maine. There's a vacancy now. Recently, Judge John Woodcock announced that he will take active senior status, which is also something we might want to mention what that means. That took effect this summer, but it means there's a vacancy here in Maine. So, Keith, walk us through what happens now. Now that there's a vacancy in Maine, what is going to happen and how does it work?
Yeah, so I would echo something Lindsay said, where it's not as if there is one set process that is set in stone, one across states, but even within states. And that applies to Maine as well. There isn't a one format that happens every time. But the way it's working now is Senator Collins is supposed to be consulted and has put together an 8-member commission, not a formal commission, but an 8-member advisory group to advise, take applications, and then ultimately Senator Collins recommends 2 to 3 names generally to the president to nominate. And those commissions or advisory groups or informal task forces, any of those also should reflect the same diversity that we want to see within the judiciary, because they're the ones recommending or picking or vetting. So one noticeable part of the process here in Maine is that we haven't heard that they're actively seeking or recruiting, which is the process in a lot of states. And so it's left to who is actively seeking a nomination. And that also would be a difference if there was a body who was actively recruiting and making sure that there was diverse representation within the applications that they were considering.
Can I stop you for a minute?
Yeah.
So what you're saying is people just have to want to be a judge, and is that what you're saying?
Yes.
Okay. And
Or, can I add, or whoever is in the committee, they might know people. So it's a little bit of like, if you're in the inside club and know the right people, they'll encourage you to apply.
But who's on that committee and how does that get picked? Who are the 8?
So I'm looking at Eliza. It's not public. The only reason we actually have the 8, and I don't have that written down, is because Eliza picked up the phone and called Senator Collins and said, "What's the deal? Talk to the chief of staff." My guess is her chief of staff leads the committee, chose those people. And I encourage you all, you Maine residents, to contact Senator Collins and ask about her committee and say, what's the status? They were supposed to start vetting applications this summer. We're in September now. So, and how do you decide who's on the committee? Number of law students or lawyers in the room, perhaps you could be on the committee. How do you get on the committee? Those are great questions for your senator. What's the role of Senator King in this process? Other great questions to ask, and then share it with each other.
And Senator Collins is the senior senator, that's why she gets to pick. No?
I don't know.
Okay.
She's also the Republican senator, and we have a Republican president. And I say I don't know because, as Keith said, it really depends on the state. And I don't know if you have more to add to that.
All right.
That's a
so-
good question. There are some states where both senators work together. And I'll take Pennsylvania as an example, where there's a Republican and a Democratic senator, and they work together on culling names. They also have a lot more than one vacancy, but that's a different panel.
So let's say we get past the panel part, the committee part. Then what, Keith?
So after generally home state senators are consulted in some way, traditionally, again, not set in stone, whatever it is in that state, then they send a few names to the White House. The president officially nominates one candidate who's then named. Remember the two qualifications: nominated by a president, confirmed by the Senate. So that nomination first goes through the Senate Judiciary Committee, where traditionally, again, this is all traditionally, the nomination won't move forward until the home state senators have returned what's called a blue slip. It is literally a blue piece of paper signaling that the senators approve the nomination moving forward. Doesn't always show that they ultimately support the nominee, but they're supporting the process moving forward. After that, the chair of the Senate Judiciary Committee schedules a hearing. There's a hearing. Then there's a committee vote. When the nomination is passed on to the full Senate floor, there's a full Senate floor vote. One important thing to note is that there is not a filibuster, that it's a simple majority on the Senate floor to officially say yes to that nominee.
That
Sorry.
was done away with a few years ago.
Just for district and circuit court. The Supreme Court, future Supreme Court nominees at this time still need a 60-vote majority. You're going to change that? No? They
No,
take-
that was a rules change that occurred to confirm Gorsuch.
And part of the
I'm sorry.
part of the hesitation here in the process is that some of these things have changed based on who's being nominated, right? And so, whether it's Specter or Orrin Hatch, if you don't like the blue slip process, how it's playing out, you say, we're not going to do the blue slips for these candidates, right? So none of these things are in the rules, right? In the Senate rules, they're traditions, right? So traditionally for lower court seats, both state senators have had to approve of the candidates, but that hasn't necessarily been the case over the last 2 years, because if there was a candidate that somebody wanted to push across and they were not getting the blue slips, they might still push the candidacy across. So these are all kind of customs, but as Keith said, nothing is written in stone, and the party that has the political power can change the rules when it wants.
I'll be really quick. And we're going to see that with the blue slips. We have 2 states where senators have not returned their blue slips. And so we will see now what the Senate Judiciary Committee does in Oregon and in Minnesota with 2 nominees.
All right.
And I would also add that this goes back to the question about almost the politicization and the overlap between politics and nominating people who are supposed to be impartial. Senators are partisan. Committees are partisan. It is inherently a partisan political process in that way based on the Senate.
All right, but what does it mean now that there is a Republican president, a Republican-controlled Senate, smooth sailing or not for Trump's picks, that he has a lot of?
He does have a lot, remember that, over 140. Well, one procedural move that people can make who are in the minority party is actually what Lindsay mentioned, which is withholding that blue slip and not moving the nominee forward. Again, not set in stone, is a 100-year tradition, but that is one way within the process for the minority party to still exercise some control. There are also some other procedural moves, like taking advantage of the rules that allow for 30 hours of debate and dragging that process on and delay. Then on the flip side, the committee chair also has a lot of power in terms of just setting a schedule. Scheduling a hearing can dictate whether a nominee is fast-tracked or isn't, and what the priority is there. Or stacking hearings with a couple of controversial nominees so that time runs out and they're not thoroughly vetted during the hearing. They're not thoroughly questioned as in-depth as they should be. And so those are some of the along the way moves that people can make to influence the process.
So it sounds like you're saying, you both are saying, that the process is not working the way it's supposed to.
I think it's that it's not working in a way that's set in stone.
So are there ways to change it? Is that what will you be working on that?
We're not going to be working right now on the process per se. We will be working. We're getting involved in the process, and that's kind of the role we play.
And okay, so that brings me to wrap this up before we go to the audience questions. What can members of the public do to get involved, other than what you mentioned about reaching out to the members of the delegation, the 2 senators here in Maine?
Yeah. So I think I'll just say, when you leave tonight, just carry the message with you that courts matter and that you as constituents have a role to play in that. So I kind of jotted down 5 things that you could do. The first one being, save your senators' phone numbers and emails in your phone and let them know courts matter. And when a decision is made on an issue that affects you, call them again and remind them that courts matter and you're watching the process and them. If you work in a community-based organization or agency, and there's a court decision that affects your constituents or your members, in your email updates or newsletters, let them know about it and remind them that the courts are affecting them and it impacts them. For those law students or attorneys in the room, think about if you want to be a judge and figure out how to get involved in that pipeline. You're already in the pipeline, actually, if you're a law student or an attorney, and start asking around. Ask Eliza who's on the commission, maybe you know, or the committee, maybe you know some of those people and can figure out how to get yourself in that process. And related, get yourself in the committee or the commission that your senators put together. If you're more of a behind the scenes and don't want to necessarily sit at the court. And then lastly, there is a Courts Matter to Maine coalition here in Maine. You may or may not know, if you signed up for CLE credits, you also signed up to be added to the listserv. So thanks. And that's chaired by Maine Women's Lobby. No, I'm saying it wrong. Policy Center, I'm so sorry. And it's put together by nonpartisan and faith-based groups to educate more people in the state on the issue and engage in the process. And just keep talking with people when you leave tonight. Talk to your friends, families, and coworkers about this issue and what they can do.
All right, thank you. Anyone else want to say anything about that? If not, we will turn to the members of the audience who may have questions. Does anyone have a question? We're going to be passing a microphone around. If you could just raise your hand and we'll make sure you get it, if you'd like to ask any of the panelists a question. Okay. You want me to use? Can I borrow your mic?
So I'm thinking that maybe we should start saying it's too important to be left, if war is too important to be left to the generals, that the courts are too important to be left to the lawyers. I was also thinking of how to dramatize, and I should make a confession here, I work for the National Council of Jewish Women as well. How can we dramatize this issue a little bit more to people? And maybe we should take a lesson from those promoting judges we don't like, and talk about cases where judges made important decisions and what it would be like if they didn't exist or they weren't on the bench. I think, for example, of the nurse who Governor Christie put in a tent when she came back from Ebola treatment and then we had a state judge in Maine write a wonderful decision that, overturned that attitude and LePage's actions, which would have just done basically the same thing. Because I think when we say courts matter, it becomes a little institutional, and we're now at the point where both sides are talking about judges matter, and if we could hold up some examples of why they made a difference and what it would have been like if they weren't on the bench, maybe we could get through to people who are thinking that this is pretty dull.
Yeah, I'm glad you brought up that example. This was the Casey Hickox, who was the nurse. It was big national news for a while, and it was a case here in Maine. And the two reasons why I'm really glad you brought it up is, one, it was just a really remarkable example, a shining example of what a judge can do, and when they see beyond the moment and recognize the sort of transcendent issues implicated. And this was the state and the governor, the Department of Health and Human Services saying that this person needed to be quarantined, confined against any medical or scientific evidence, and a judge saying, no, that's not what the law says, that's not what science says is appropriate, and she has freedoms and liberties. And the second reason, sort of related to the first, is this was a judge, not a U.S. Supreme Court judge, not even a federal appeals court judge. This was a Maine state district judge, which is like the most basic courts in the state that are used to dealing with very minor disputes and low-level disputes. They don't do jury trials even. They just have disputes that are resolved in front of a judge. And the Chief Judge Laverdiere, who's the judge in that case, just really rose to the occasion in a way that was almost sort of brought a lot of us to tears. It was remarkable.
And it really changed the climate in the country, that particular case and how he ruled on it, because there was a lot of fear, and we didn't really know how it was going to play out after Casey Hickox until that.
Yeah.
Anybody else have any questions for the panel? Oh, sorry. Yes.
Yeah, so this is a little bit removed from the discussion so far, but it's an idea that I've daydreamed about, and I was hoping to get some commentary on. So if the Democrats were to have unified control in 2020, I know people are, it's speculative, right? But if they were to have unified control, I'm wondering whether, and I've seen this idea floated a couple times, but not much discussion of it, whether there's any chance they think about adding 2 Supreme Court seats as retaliation for the refusal to confirm Merrick Garland. And so in my own mind, I think it's not realistic if we don't have a second Trump appointment. But if we did get an appointment, let's say to replace Justice Ginsburg, and we were in a world where Roe versus Wade was in real danger of being overturned and all sorts of other issues really veered pretty harshly to the right, the court's jurisprudence, I think it would at least be on the table, right? I don't know if it would then become a 2020 election issue, and then at that point, if it did, then they could say they had a mandate to pursue this. Anyway, so that's just, again, a scenario that I've daydreamed about, and I was wondering if, I guess 2 questions, you can answer either or both, whichever one you feel comfortable with. One would be, is it politically realistic? Again, I haven't seen a lot of discussion of it, except among other daydreamers. And then the other question would be, do you think it would be worth it, right? So if I look at your bios, and setting aside Dimitri's, which is pretty apolitical, but if I look at your bios, I think you would want maybe on some level the Democrats to do this, but it would come at a real cost to the court's legitimacy, right? So is that short-sighted gain, or maybe it's not short-sighted, but is that gain in the change in direction of the court worth the cost to the court's legitimacy?
I'm sure people are going to be able to give a better answer, but I'm going to just reject your hypothetical first because Justice Ginsburg is going to live forever and she's not going to retire. But maybe there's another judge, so we'll just go with that.
I mean, I will say not feasible politically. Now, you know, so obviously we have a long history of ideas like this, right? So we had the FDR court packing plan, right? When the FDR wasn't getting the decisions that he wanted, he came back and said, you know what? Let's create some more judgeships. That was pretty universally rejected, right? Even though the Democrats had complete power, still there was kind of very negative reaction to this idea that we're going to create seats to try to get around kind of the five conservative justices on the court. Now, it has happened in the past, right? When President Adams was leaving office in 1790s, right before Jefferson comes in, creates a whole bunch of judgeships, right? Because the idea is the Federalists are going to entrench themselves in the court. So it has been tried, but I do think the hit to legitimacy would be a concern for Democrats in proposing that. So maybe as a last resort, but I don't see that as a feasible option.
Yeah, so I know people in Colorado are trying to add judge seats because of capacity reasons, and I don't think they've added any judge seats yet. So I don't know if the Supreme Court is different than the lower courts in adding judge seats, but just at a lower court level, it hasn't happened. I think we'll see what happens. Republican senators have proposed splitting the Ninth Circuit, and so we'll see if that's feasible, and then what that leads to. And then I just have to add, I think Roe v. Wade is at risk at the current landscape right now in the Supreme Court.
All right, we have another question over here.
So I understand this is geared towards the federal court, but I just wanted to come back to a point you made at the outset, which is cases are about people. And in Maine, the federal system moves pretty quickly. But the state system, especially in New York County, is completely broken, where it's gone from 1 year to resolution of a civil matter to 4 years. Any thoughts on the state system?
Yeah, that's a great reminder that, you know, I think Zach made the point that, you know, there's 9 justices in the U.S. Supreme Court that hear 75 cases a year, and then the lower federal courts hear thousands. If you look at state courts, tens of thousands, hundreds of thousands of cases, right? If you look at the numbers, state courts hear probably about 80 to 90% of all cases in the country. For most of us, for most people, their interaction with the judicial branch is going to be with a state level. And so I think it's an important reminder. I mean, you're right, we have focused on the federal courts, but the whole kind of courts matter notion, we've got to be thinking about state judges as well, right? And the same kinds of considerations play out there as well. And in fact, the point that was raised about independence of judges, that's maybe more problematic at the state level, where there's, you know, in Maine it hasn't been as much of a problem, but of course we have 7-year terms where the governor reappoints. Throughout the United States, most judges are elected, right? And so they're running for elections, and so the political considerations play an even bigger role there. So I do think for kind of those of us in this room, thinking about the role of state courts and seeing the same kinds of problems there is at least as important as what's happening in the federal courts.
I would actually connect that to the comment about almost demystifying the courts. Is, you know, we talk about the federal judiciary, and we talk about the courts and the judiciary as a protector of rights. That's our vision. But for a lot of people, their interaction is with state court, is with a criminal charge, not being able to pay bail. And so we need to make sure that we're incorporating that is where a lot of people are starting from, and not assuming that they see the court even as a potentially positive protector of rights.
Just, you know, and just to add one more point is that the two are not independent of one another. Here in Maine, one of our federal magistrates, one of our Judge Nivison, one of our U.S. district judges, Judge Levy, and one of our appeals court judges, Judge Lopez, all started in the state court system and now are in the federal system. So there's connection.
So I would just add, that's a good place to put yourself in the pipeline to be any judge.
So along those lines, and Lindsay, according to one of the suggestions that you had mentioned about getting involved, what we can do, So one of the things that you had mentioned was law students and attorneys becoming judges, hopefully becoming judges. And also with the notion that Dimitri had mentioned that President Trump, we're now seeing a lot more judges who are much younger and are being on the court for much longer extended periods of time. So for those law students, those attorneys who are considering, and who may have not considered it before, but perhaps you've sparked an interest with this, this panel here, what would be your recommendations to prepare to hopefully go down that line?
I'm looking at the attorneys on the panel.
We're all too old.
I mean, what comes to mind for me is first, like contacting your senators or those who are part of the process for your state courts and just getting more information, especially if you plan to stay in Maine. Start asking questions. How can I put myself in the pipeline to become a judge? What do you recommend? Try to get some coffee dates with people who seem to be part of that process. Ask your law professors.
Well, the old joke used to be that if you're going to be a federal judge, you should go back to college and become roommates with the senator, right? So that's the easy way to do it, right? But you know, at the state level, where there's a lot more seats, the people who become judges are oftentimes kind of the good lawyers, right? And so developing a reputation for yourself, being a strong lawyer, being active in the community, those are often the people that are sought out, right? So they're oftentimes the top lawyers in town that are kind of people think about, hey, this person has the right temperament and demeanor and experience to be a judge. So it's kind of a career reputation over the course of your career.
And actually, it would just occur to me, become a clerk for a judge and get yourself in that kind of network in that position.
All right, any more questions from the audience? Yes.
Actually, one of the things that, sorry, I have a loud enough voice, I'm sure they can hear. One of the things that wasn't mentioned, I'm sure there are a lot of people that would love being a judge, but unless you have the money to leave, like say, a private practice, or you're doing well, that is a big consideration for many too. I mean, many of these, shall we say, top lawyers are making so much money in big firms that if they have a family, if they've got children going to college, if they have parents that they're helping out, they have to be in a position monetarily to leave that job that they have to go and become a judge. And that's another thing. It would be very nice if there are many that you'd love to see as judges, but because where they stand within their own family and monetarily, they can't do it. Maybe down the road they can, but we need them now with all the, so that's a consideration also. I mean, the, legal profession, especially in big firms, has afforded so much money that this is an issue, and that was something that wasn't mentioned, but it would be very nice to have some of them.
I would then kind of put the question back at you is how can a community rally behind someone who has a diverse professional experience, but perhaps not that kind of wealth, that financial support to be in the process? What could others do to help that person kind of consider that as an option? And thank you for raising that point.
And we've mentioned the word pipeline a couple of times, but I think that also speaks to how can we make sure that the entire legal community, including criminal defense attorneys, including public interest attorneys, are in that world of being even considered as judges, so that it's not a whole lot of people with the same background in power, honestly, than sitting on the bench and deciding which side to come down on.
All right, are those all the questions? Thank you so much. Those were great questions. And thank you so much to the panel, Zach Hayden, Lindsay Morris, Keith Tyrion, and Dimitri Baum. Really great. Thanks so much.
Thank you.